Hello friends, this is Binay Kumar Sahai, retired Principal District Judge. Today I am telling you about the recent judgments of Honorable Supreme Court on maintenance. It is well settled that maintenance is a social legislation and it is for the social justice. The judgment of Honorable Supreme Court has been passed in 2021, which is reported in SCC 2021 Volume 2, page 324. The judgment has been rendered by Honorable Mrs. Justice Indu Malhotra. The judgment is very drastic and you will understand the importance of this judgment that there are guidelines and the copy has been circulated to all the high courts across the country. The Registrar Generals of the high courts have been directed to circulate the copy of the judgment to all courts in their respective states. It has been held in the judgment that the maintenance amount should be payable to the wife just to prevent the wife from falling into destitution or vagrancy. Of course, it includes minor children also and the old parents. The quantum of amount of maintenance has not been fixed. There cannot be a straitjacket formula for deciding the quantum of maintenance. It has been left at the discretion of the family judge that what should be the amount of maintenance. It should not be higher so that the husband may not be able to pay the maintenance. It should not be lower so that the wife cannot live comfortably. She is entitled to live comfortably as in the same style as her husband is living and she was living in her matrimonial home. There can be overlapping of orders. Suppose a wife files a maintenance case under section 125 CRPC and simultaneously she files a divorce case under the provisions of Hindu Marriage Act and or the Special Marriage Acts, and the maintenance amount is awarded under section 125 CRPC and simultaneously under section 24 of the Hindu Marriage Act as interim maintenance or under section 36 of the Special Marriage Act. Then what will be the remedy? It has been left to the court to decide to the quantum of maintenance, to set off the maintenance amount and to consider that it should be what should be the amount of maintenance. There can be overlapping of orders. So just to it has been left to at the discretion of the court to set off accordingly. Further, if the husband does not pay the maintenance, then it has been held by the judgment that if the husband is able-bodied and he is not doing anything, but he is duty-bound to maintain his wife by physical work, and a further case arises that suppose wife is doing some work and she is earning some money. But it has been given to the at the discretion. It has been given at the discretion of the family judge that to decide that whether the facts and circumstances of the case justify, whether the income of the husband, whether the income of the wife is sufficient, and if it is found that it is not sufficient, the husband is bound to pay the maintenance. And it has also been held by Honorable Supreme Court in a judgment of Madhya Pradesh in Sunita Kachwaha, which has been passed in 2014. Then the wife was employed as a teacher, but her income was found meager, and as such the husband was directed to pay the maintenance. Suppose if the husband does not pay the maintenance and defaults in making payment, then it has been held that it should be treated as a fine, and it should be realized as a fine and under section 125 clause 3 of the CRPC. And a remedy has also been given to the court to take the provisions of Order 21, Rule 51, 55, 56, 60 and 68 of the Civil Procedure Code, and that should be realized as a money decree. It has also been held that the maintenance amount can also be treated as a money decree, and that provision can be applied to the maintenance case also, to the ad interim maintenance under section 24 of the Hindu Marriage Act and section 36 of the Special Marriage Act. Now I refer to another judgment of 2025, which is Reena Kumari versus Dinesh Kumar, which is reported in 2025 volume 1 Supreme Court, page 85, that husband has obtained a decree of restitution of conjugal rights against his wife, but wife refused to live with him on the ground that it is very difficult for her to live with the husband. It has been found, considering the facts and circumstances of the case, that wife was justified in refusing to live with her husband, and husband cannot be absolved from paying the amount of maintenance, and husband was directed to pay the maintenance to the wife. Further, it has been also held in the protection of women from Domestic Violence Act under section 18 and 23. It has also been held that if the husband and wife are living together for a long period, similarly under in a maintenance case, then the wife is entitled to receive maintenance from her husband. But it has been held that if a man and woman are spending weekend holidays together and there is one night stand, that does not come under the purview of husband and wife, and it does not come under the purview of domestic relationship. Today I conclude this video. I hope and trust that you will like it, and please do not forget to hit the button of like and subscribe. Thank you. On the next day I will come with another topic. Thank you.